Well, hello everyone, and welcome to Mutual Knowledge podcast. And today I am blessed to have Casey Cholle as a guest. Did I pronounce your name correctly?
You did perfectly, Casey. And well, Jolly is a little bit English, but it's French, so Jolie.
Alrighty. Okay, hi, nice to have you here. Well, could you introduce us about your to your background? Today we're going to talk about intellectual property and in relationship with the field of AI. That's a very tricky subject, and the responses are probably going to be very different if the question is about European intellectual property or about US-based IP. So, can you first of all tell us where you come from, how you came to this beautiful topic?
Okay, so first of all, how I came to it, and then where I come from, because where I come from is a little bit complicated itself. How I came to this, I came to AI through Web3 technologies and particularly blockchain. I was working in 2021 on issues, like many people who were in blockchain, about traceability, provenance, and authenticity of content in the Web3 world. So also applied and specifically in what we were working on for that blockchain protocol that I co-founded. It was specifically as well for works of art. So we're very close to what we're speaking about now. So when Gauthier, blockchain was more or less moved towards the door in favor of AI, and all the investors jumped on AI. I at that point in time, I was still sufficiently naive to think that there was a real convergence possible between blockchain and AI. In truth, it's AI and blockchain on the sides or on the margin today.
Most likely, yes.
Yeah, so that's how I came to AI, with all the fascination of emerging technology and all of what this can bring to us, how it changes the economy. And so even though you're speaking to an intellectual property lawyer, you're speaking, if you do intellectual property, you're into economics, you're into, geopolitics and a competitive advantage, property and
Philosophy,
privatized
probably.
rights and exclusivity, so all of these things. So yes, I came to AI thinking that, maybe with the ideas that we had with distributed technologies, and of course it was not at all that AI. And so here we are speaking about another type of AI today. So that's where I came from and why I was interested in AI. And my background, Gauthier, is I'm an intellectual property lawyer based in Paris. So I work out of the European Union for clients that are either French-based for their interests outside, because it's a very harmonized law. I also work for outside clients that can be US, outside of Europe clients, Asia, etc., for their interests in Europe and in France. Typically, I was approached by somebody who does behavioral recognition AI. How can they integrate this into the EU constraints, for example? So all those other issues. So I work out of Paris. And I would say that where I come from a double background, a very mixed background culturally, Gauthier. And I think this is something that is in um, my own genetic composition, and it has become my mark as to how I think law, how I think about AI. So I never come at it only from a French perspective. Of course, English is my native tongue, so of course, culturally, I also have that in my mindset. So yes, I would say I do work out of Europe. I am based in France. I'm not a typical French thinker in intellectual property or in AI in general.
Well, that's lovely, and I like the fact that you come from Web3 because that's a spectrum of technologies I'm very fond of. We at Mutual Knowledge have a huge Web3 branch, and that brings me to the first question about IP and AI. Is it relevant for you to to separate, because some people do that, to separate AI training. So there's a debate about intellectual property to train AIs, and mostly pattern recognition AIs, such as those that recognize license plates or art pieces of art. And on the other hand, there are AIs that produce content, so they have been trained the same way, but there's an extra layer of philosophical debate about the nature of the content. So is it relevant for you to separate those two?
I think it's relevant today, Gauthier, for what we're going to be speaking about, to um, to stay on the line of how LLM models work in general. That's all the IP litigation is based on, that economic reality. So I would always stay on that. And for the people that are listening in, I would like to maybe simply say, without going into too much technicality, that in foundational models today, when they have been trained on IP-related content, or I would say, let us say, that created content that is eligible for protection under copyright and author rights. What we have to bear in mind is there are different moments in the training of the LLM model. And for me, the two moments of the basic training on the data sets that are then brought together and by these different LLM models, and then the fine-tuning stages, and then perhaps the RAG stage later on. Those are the main stages that we have to sort of alight on to understand how this is impacting intellectual property law. And I think just the basic thing that I wanted to say is the debate today is really on how have AI models used protected content in their development? And these are huge questions today. I mean, I'm just putting it over to you now because they are huge questions in intellectual property.
All right. So the layer, well, basically, producing content is a trivial question, and training the model, whatever it is it a language model or an image generation or a convolutional network, whatever, is more the center of the debate these days. All right. So in France, we have a very common strategy to do that. I mean, common in the sense that France does that for every piece of art. Like we have institutions. So we have the CNC for filmmakers. We have the SACD for script writers. We have the SACEM for music players, and the FabJV for video games and so on. So we have every time we have a public institution that taxes the hell out of produced contents, and then that is going to subsidize other people. If I were a gambling man, I would say France is probably going to chat every chat GPT image generation or so. But what else? What would other countries do, like Denmark or Germany, or, well, people who don't have taxation as a national sport?
Wow, that's a huge question. Wow, you're going like real heavy on that one. Okay, so wait, let me just come back just shortly on that question of taxation. I know that the French is a very, they have organizational layers, particularly with regard to collecting societies, etc., that enforce rights for authors, and that's what you referred to. And then you refer to, in general, taxation, which is usage of protected rights, and then how you would have to pay through the collecting societies, etc. And then taxation in general. Now, I would just say one little word on taxation, which is that, yes, we have had very commissioned reports done on AI, and in that whole development, we've had the idea that we could try and bring together the LLM model producers and authors and start to build a sort of negotiation or some sort of conversation in which they can have an understanding as to how deals could be made with regard to bringing fair compensation, and into how how can we attribute better protected content in these AI models? So that has actually gone into place in France. And so I'm going really quickly now. There are certain things that are currently under discussion, such as a legal presumption. And beyond that, it would be that they would tax, basically. So yes, I understand what you're saying about taxation. Somehow, I think it's going to be much more subtle than that.
Ah. So
And
I won my bet, but I'm just slightly off. So what would be
yeah,
the frameworks and guidelines then?
well, I think that we have, first of all, need to look at what's going on right now, Gauthier. And what's going on right now is that we've come from a situation, I would say, in 2024, which is a situation where we were really asking ourselves a question. I mean, is this trademark infringement or the use of protected content in LLM model training? So this was a question mark. Was it fair use under the US doctrine, or was it fair? Did it get into the exception of text and data mining and the EU understanding? These were question marks in 2024, and now we got some clarity on those issues in 2025. Which is what we're seeing today is, because there have been a certain there have been a certain amount of litigation in the US and some in the EU. We're starting to get some clarity on those issues. We have now seen that licensing deals are developing, particularly in the music industry. So I think there's a whole set of benchmarking, there's a whole set of reaction that's going on right now, specifically with the right holders. And we're not speaking about authors, we're speaking about, when we speak of right holders here, these are people that own catalogs, musical catalogs, that own, that are press editors, etc. So these are the middlemen, and these are the ones that are negotiating right now licensing deals. We've seen them with Suno, Audio.
I was about to bring it up. Okay, so I have a comedic rap band on Suno. So basically, I produce junk, bad-tasted rap, and just for the sake of making my friends laugh. But I saw their license agreement. You're not allowed to commercially exploit what you're selling or what you're producing unless you keep paying the $9 per month license fee or so. So does that mean that a share of those $9 are going to go to the artists that whose content were used in order to train the model? Does that mean this?
I don't think so at all, Gauthier. I think we have to separate out two things. First of all, you're speaking about terms of use, and all of these huge platforms have terms of use in which they try to provide some clarity with regard to the user of the platform, to indicate that if you are using the platform, the generated output of that platform, first of all, is that at all concerned by intellectual property rights? Are there rights? Who owns them? Or can you use, even if they don't go into the question of ownership of IP rights, can you use and under what conditions? That is one point of it. And the other point of it is, and that is what the Suno and Udio deals really are about, is it would seem, because of course these are now private discussions, so we are not, there have been a lot of reporting on those, and I'm relying essentially on what is reported in the press, because you don't have that confidential information. But what comes up very clearly is that we seem to be going towards a very pragmatic approach that resembles the streaming model, which is not necessarily the most generous or respective model for authors. So we have to wait and see. Part of this is a wait and see element. I don't particularly think that, and we have had associations that represent authors that are very, very concerned about whether this is going to be protective at all of authors in the middle or long term.
You know, I was discussing the other day with one of your Chinese counterparts. So that person was basically 1 foot in two worlds. Well, both feet spread across China and the US. And that person told me in China, the IP model these days is much more restrictive as 20 years ago, because now they have tech that people could copy and use unlawfully. So they have to respect IP and not copy, like not ruthlessly copy US technology. Otherwise, people are going to copy Chinese technology. So that's a good thing. But he told me regarding AI and author protection, the Chinese philosophy these days is to not hinder innovation. So wait and see. We're not putting any rules now, and we'll definitely put them in a few years, maybe in a decade. But we don't want any rule that would hinder innovation at the moment. So that's another different philosophy. So we talked about the EU, China, and what's the difference with the US? Do they have the same author protection framework, or is there something intrinsically very different?
Okay, so another huge question here. So if we start off from the EU perspective, we can say that there's a more human-centric model in that it's more based on the protection of the human, and you have things that such as moral rights that you don't have, that are not as well understood under the copyright principle. So that's one of the differences. And then it plays itself out in many different ways. Gauthier, if you want to go just, and I want to go, I think I'll do EU, US, and then we can go to China afterwards.
Please.
So if you go EU, US, there are other things that are very different. First of all, I spoke about fair use in the US, which is a certain doctrine that has been developed under case law that in which such training, such as the case law that was under Google Books, where they did accept the fair use principle. The same question is now underway with regard to AI, which is like the Anthropic case that we had that was decided in 2025. So basically, the question is, when you used protected material to train an AI model, was this fair use and transformative for another type of industry? We have had decisions that have been positive, and I do think that the huge LLM models were clearly advised on those issues before they decided to launch all of those models. And we may very much be going towards a wider acceptation of fair use, which may explain why we're going into a lot more licensing today as well, Gauthier. So we have that question about fair use. And then we have under the EU not at all that notion of fair use. We have a text and data mining regulation in which the EU accepted that there would be an exception to copyright rules, which is you must get authorization to reproduce a work of art. That's the principle. You can have an exception if you are doing text and data mining. And there I would say that the understanding has been a little bit different. Well, it has been different because it's different in substance and in parameters and criteria. And here I would speak a little bit about the JAMA decision that was done in Munich in last November 2025, where the judge accepted that it did come under the text and data mining. So the use of protected work in training of AI models. So he did actually accept that that can come under the aegis of the text and data mining. And he drew this distinction. And it's not, I'm going to say it in 2 words, it's very easy to understand. He drew this distinction, which was, if the training was merely analytic, so it's analytical so that you can understand certain aspects of the work, etc., then we are in the text and data mining. However, if the training meant that it actually memorized the entirety of the work of art and became a reproduction, then you were then in the subject matter of a copyright, and probably there would be a violation of copyright. So you see, US and EU are different things. I just add in one last thing there before I go in, because it's a huge question which you asked me. So just give me 2 minutes there.
Please,
Lucy.
please. The place is not rented. We have all the time we want.
Okay, so the other third perhaps difference I could give, of course, there are many others, but within AI, because I'm keeping a clear, line of IP AI, is that of opt-in, opt-out. So what we're seeing in all these licensing deals, for example, we spoke about Suno and Udio and all of those, is that they're providing opt-in possibilities for rights holders to build curated catalog deals. So these are very specific catalogs. You opt in because you can find an interest into that particular catalog deal, and it comes into a data set, and you get that particular compensation within it. So this is the point of view from the US, where they're doing this opt-in model, and the EU has an opt-out model, which is to say that we go back to the text and data mining. How can you show that you don't want the robots to scrape up all of your content? Well, you must opt out. And in the EU, we have a lot of the collecting societies, such as the SASEM you referred to, etc., who have opted out for all of their authors. So
Nice.
you see, it's very, very different from one stage to the other. I'm coming to China. Let me just come to China.
Let's go, yes.
So China has a different outlook that's always so much more pragmatic. And I think that AI works well with being more pragmatic and less principle-based approaches, okay? So one of the things I want to say about China is that, two things maybe. They understand very much economic interests very quickly, and they identify them very quickly. So, for example, that's my first point of view. My second point of view, that we Europeans really have to get out of this old image that we have of the Chinese, that they are basically imitating our rights and stealing our IP, and that they don't have their own IP, or that we don't even need their IP. I think we need to really review in the light of the reality of what's going on today. And I want to bring to that 2 points. The first point is in the way in which, in the very beginning, the Chinese have taken on the issue of AI-generated output. Is this protected content or not? They have taken a much easier line on this. It's more pragmatic and it's much easier. So just to put things very simply, in the very beginning, and the first decisions that were taken with regard to Tencent and all of those other big platforms, what was decided? It was said, they have actually, in fact, it was considered, did a lot of prompts, and all this human input meant that by the choices that were made, we can consider that it adds up to copyrighted work. Okay. So just
to get you correctly, the prompts in China are something that could fall under copyright, where it couldn't in the US, right?
Right, exactly. In the very beginning, their whole approach to this was there was a lot of human input, and so we could consider through the prompts and other things that we were actually, the output could be considered as eligible and entitled to protection. So they took this particular and specific example, and they came to the result, this is eligible for protection. Okay, so that's what we need to hold on to. The Chinese are saying, so this output is eligible for protection under author rights and copyright. The US have taken a position that is different. They've said creation is linked to the human, and you can't have an invention, for example, under patent law, or under creation under author the copyright, if you don't have a human. So 100% generated output is not protected by copyright and author rights. That's fairly clear. But then if we go back to this very first decision, was spatial, and that's a very interesting decision. I'll just give it to you in a nutshell. Gucci. So this was the very first work of art by a Colorado artist that was awarded, and it was done by AI. And it made up a big thing of, obviously, it came out in the press as well, because it was the first AI-generated work of art that was awarded. And then the author then decided that he wanted to get it protected under US copyright, because in the US, you need to get registered copyright to do a certain amount of acts and to defend your right properly. So which is what he did. And then the US Copyright Office then said to him, well, you have to disclaim what was human, what was machine, because the machine is not protectable and the human part will be protectable. So you see, we have this dichotomy under a US understanding that's not far from the European understanding of the human input. And then the Chinese have taken this very pragmatic point of view. So what does that mean? It means the Chinese are saying, when you're using copyright, I'm not generalizing, I am generalizing, but we have to remember that each litigation is a specific case, but I'm just giving you the idea of what has come out. The Chinese are saying, when you're using AI, you can have eligible content. You can have an output that is eligible for copyright, and that means you can monetize it, you can license it. Gautier, you have it can be licensed rights, okay? And then you have on the other side another system that's saying, well, if you only just hit the button, I don't care if you do 400 prompts, it's machine generated, so no copyright. So you can't license that right per se because it's not copyright, okay? So you can see the balance that's being done on one side to other. So yes, the Chinese have a very pragmatic way of considering things. I just want to add one thing with regard to the Chinese as well. They're not the only people, but they have come at the issue of data in a very innovative way. Now, data is inherent to AI. No data, no AI, okay? Only that the Chinese understand, they have done and modernized their law so that data itself can be an asset. And that goes very far. It means that you can actually take your data set and get it pledged and finance your whole project with the bank based on your data set, because it's recognized as actually having economic value and also having legal value.
Good God, wow, that's very impressive.
You see what I mean? They have this very pragmatic approach, and we don't have. And a point in fact, and I will come to that in the end, we have this whole incoherence on data, in which for us data is information, and information means that you have to have, it must flow freely, and it means that you have a right to express yourself totally, so that you can't have a privatized right on information. So we have this whole philosophical bind here with regard to data, which means that the whole question of data as an asset is not so clear from a legal point of view. And they are very clearly saying, well, data is an asset and you can pledge it. It's very interesting.
Yeah. That kind of reminds me the debate we had with peer-to-peer networks and piracy in the 2000s and the 2010s, because some people were saying, well, IP is overrated because when you download a movie out of license, that's technically illegal, but you're not subtracting the use of that data from another user. So the model cannot state that this is a theft. That's something else, because you're copying data. You're not taking physical property. And well, I'm retrieving these vibes and I like it. Like China is realizing Web3 enthusiasts with dream to say that data is, you should have sovereignty on your data. That's an asset like any other. I like it.
Yeah, and there's not only China, the Middle East are very good at that as well.
Oh, like you have examples?
Well, there are laws that have been passed. For example, if you take United Arab Emirates, in which they have been very innovative with regard to data, also because they come at it, they are newer states. Of course, you are very held in the bind of your past judicial precedents and your understanding of how you construct law, whereas I would imagine for more modern and younger states, they can come of it from a whole different point of view that is new, innovative, and that they in fact have in Dubai in regard to data, which is a huge, it's a huge basis for their whole economical structure over there as well.
If you allow me, I'd like to draw a bridge between technical concepts and legal concepts. So I know, so for the general public, I know two main ways in order to circumvent an AI, to prevent it from generating copyrighted content. One is the AI filter, the very tiny layer. It's sometimes even just keywords, so not technically a trained model, just AI. That type of content can be restricted. For example, I have a good friend whom I had interviewed on this channel, Bilal, if you're watching us. But basically, he said in an interview he tried to generate a music from David Guetta and couldn't do it. But when he wrote David Ghetto, that worked. It kind of reminds me of when Bruce Lee died. There were copy pastes like Bruce Lee, Bruce Lowe, and Bruce Lee with an I. And so that's the first way to do it. You can say David Ghetto, and the AI will then try to make something like that. And the other way is just to not train the AI. But the problem is that, for example, if you ask ChatGPT about pornography, the first layer is going to filter it out. But if you practice prompt escalation and know exactly how to ask, ChatGPT will write hardcore pornography. And same thing, the descendants of Martin Luther King asked Google to restrict the keywords because too many people were using the image of Martin Luther King. But still, you have to train the AI with Martin Luther King so that it knows what it is. And same thing for adult content. If you feed the AI pornography so that the AI can tell you, no, I'm not using that image because this is porn, then that means that to some extent you have to have trained your AI with a bit of it. And same thing for anti-Semitic or whatever, sexism, homophobia or whatever. You have to feed that to your AI. So my question is, are there already technical frameworks? Because it's a paradox. You have to train the AI so that it knows that this content could fall under copyrighted law, and you cannot only use that first layer, because if you just use that, people who are smart are going to prompt escalate and hijack it. Like everyone knows how to do that if you are a good prompt engineer. So are there technical limitations regarding the training of models to circumvent that, or is it going to be something that happens because of the structure and there's no legal framework to limit the training? I know it's a tricky question.
Yeah, okay. Tricky question, but I'll try and come of it as an IP lawyer. There are many technical possibilities because under all of the things that we've been speaking about, for example, the text and data mining, this was actually about how robots crawl and scrape and how the machine read websites. So yes, we're always speaking about technology, Gauthier, okay? And so what I want to say is that there are technical possibilities today. Many already exist. We can speak about attribution techniques for authors to know to what extent can we consider that the output can be attributed to works of art that have been ingested in a training period, for example. So yes, there are technical things. There are, as you say, technical filters, technical watermarking with regard to protecting works of art, or the filtering that you spoke about. Because again, if we look at the litigation, we saw that what Meta did was Meta stripped out the metadata so that you couldn't get back to the provenance of the works of art. So those are the requirements that we see today coming out in licensing deals, where what rights holders are asking is that, there's a strict technical layer that's put in there so that all these metadata can no longer be outstripped, so you can keep the provenance. So what we're saying today, in fact, is that those technical layers exist. I would go to one other point as well. So yeah, those technical layers exist, Gautier. It's not so much the question of their existence today for me, is to how do we encapture all those things into law? You see, because we're going to speak about a lot of things today, and when people think about law, and then when they hear an IP lawyer speak about writing the rules, people think regulation. But I think that today, writing the rules is also embedding it into technology. And that's what you're exactly speaking about. How do we go about finding ways? And that's what the licensing deals are. And that's what they were asking for by requesting all this, the technical layers of not being able to outstrip watermarking, which is what the Getty trial was about, when the Getty watermark was, it came up in some of the material and the output, et cetera, et cetera. So how can we not destroy labeling that protects the provenance of the output? How do we machine readable? How do we put in a layer so that when the robots come to interrogate a website, for example, a press editor, how can they then know what information is admissible to download and scrape and what cannot be scraped? I think that those are very, very concrete realities that need to be addressed. And I know they're being addressed by some people and some technologies. So we can always come back and speak about those, because I'm not here to promote any one technology, but I would like to say that that's part of my work, which is just getting to know about all these different technologies. And I just wanted to come to one point in what you're saying with regard to technological responses to these things. My point of view in that is that we must go more and more towards more legal solutions in general, that are more neutral, that are not just human control things, but that are also where we embed the law in the technology, in the infrastructure. The compliance gets into the infrastructure. So that's what we need to embed today.
And maybe a small nuance, maybe, but maybe not. I don't know if there's a nuance between technologies, but would there be the same frameworks between technologies that produce texts like LLMs and so on, technologies that just recognize patterns without generating anything, technologies like VAEs or that generate data according to your labels, or even, I don't know, adversarial networks or diffusion networks that produce images? Would there be the same limitations or the same frameworks, or is it one size fits all in this regard?
No, I think, first of all, what we're speaking about here with IP law and AI is really guardrails that are going to be put in place, Gautier, because there are economic interests to be protected. Here, we have right holders that want to protect, like Universal, Warner Brothers, they want to protect their catalog. So we're not speaking about one size fits all and what solutions are we bringing for the user, and I will come to that. We're really speaking about what are the guardrails that should be put into place to ensure that there is a better protection, because right now, currently, we can say there is a very poor protection of IP in these LLM models. So we have to get to a better protection, so the guardrails and some of the techno-legal solutions. For the user, and then we come back to what you were saying in Suno and the terms of service. So that's the layer of the user. Certainly we have to go there as well. But maybe that's going to be a second stage of a more general deployment of technologies that would not be as expensive, first of all, Gauthier, because there is that issue. If it's going to be implemented massively, how are we going to do this so that we have a wider protection and certain guardrails that are embedded in the technology? They have to have an interest, these LLM models, to do that. So far, I don't think that they have an interest to do that at that massive scale.
That's absolutely fascinating. I like it, and I have the feeling that you opened many rabbit holes, many legal topics that we could discuss in the next decade, because obviously this is a very immature sector. And one maybe philosophical question, I don't know, but is there a pragmatic yet efficient way to do that, since to establish those guidelines or those guardrails? Because when the technology evolves faster than any regulation, that means that maybe 2 years after the regulation has been written, we're going to have an obsolete regulation. So are we doomed to bound to have just an ever-changing regulation, or are there principles that, in your opinion, are going to not change at all and to be quite constant?
Wow, okay. Yes, I'm going to take that one first. Are there going to be principles and values that are going to be not changing? Yes, I believe there will be. I want to reply on that. And then on the question of regulation, I totally agree with you, Gauthier. Today, AI is bringing an aspect of scale, as we spoke about, which means that any effect is systemic and massive. So it's exactly what you're saying. Because the code is dynamic and it's always changing and the models are always learning. So once it's done, as you say, we're already with this effect, the data has already been propagated and the effect is already there. So regulation is not a very fine-tuned response to that. And I totally agree with that. If you would let me develop those 2 points. The first point about principles and values and what will not change. I think that, we have all these wonderfully commissioned works as well. Every single time some point comes along as to how should IP law evolve. This happened with NFTs and with blockchain, as you know. And they said, no, AI, author rights are very robust and it's fine, we can handle that as well. So it always comes back to this idea that we don't need to change that much, even though we have to change certain things. And if we go all the way back into the 19th century, when photographs came, that changed copyright laws well, don't forget. And then it was able to be modified as well. And then we could do that with databases and all other things. So, okay, IP law does evolve slowly, but does evolve. And I think people need to hear that because it's very important to note. But I don't think that the essence and the core principles of the law, which are we are protecting human values and human personality. That's just one quick point here for IP. Author rights means that you are protecting the fingerprint of the human personality, okay? The choices that were made, the selection, the arrangement, the direction, the whole artistic view, all of that is what is being protected under copyright and author rights, fine. So that's really, we're protecting the human personality. In France, we speak about l'empreinte de la personnalité, so let's say the fingerprint of the human personality. I think we have to keep that. We definitely have to keep that, and I don't think that needs to change. So we stay at the core principles. Here's what needs to be changed. How do you interpret originality, which is the criteria under author rights? So we say that typically, if we consider an AI generated work of art, we would say, as long as the author has been in control of the creative process, we can say that, you know, the output would be eligible for copyright because he has controlled, he has mastered the vision, the artistic direction of the entire work of art. Fine. But as you're just saying, Gautier, if you go down the line, it's very hard to control a machine. What the machine and what AI is doing today is so tremendous in terms of spilling out all of that output that you can understand that at some point in time when you're saying the idea of controlling the artistic process and the creative process, there is going to be an interpretation that has to change there somehow. Because I don't think that the human is going to totally control that artistic process for a very long time, not in the face of AI. And so what we're going to have to see is how do we interpret that to say, and how do we interpret originality in the face of AI-produced works, which is going to be different, I think. So you see, you have to keep those principles, those, interpret others differently. And I come back to regulation. So this is one of my, I don't think that regulation is the only solution. I agree with you 100% that for AI that is working 24/7, every single moment, at going at tremendous speeds, and that is modifying in a systemic way the way in which the economy is going, a written regulation is certainly not the right or only solution. So we have to get into other ways of embedding law. We have to get into machine readable licenses. We need to get into the way in which we are auditing the infrastructure. We have to get in, just like what we did with smart contracts and blockchain, which we need to write into the understanding of the code, law understanding.
So the immutable aspect of Web3 technologies, such as blockchains with validators, would be a very good use case then for Web3, of course.
Definitely, and I still believe so, and I still think that I still know that there are a lot of people working in those areas, and so they should step forward and speak about, their proposals in that respect. I just wanted to go back one thing because I'm thinking about somebody. You have people working with AI identification of works of art. How do you trace and give an identity to a work of art from the beginning, so that, and then that cannot be outstripped, and so it goes with the work, and so that you always know. So that's an example. But I wanted to just go back one point. You spoke a little while back, Gautier, about you can't stay outside of this absolute modification in scale of this new economy that's built with AI. So you have people who have made decisions either to opt out on a big scale. So that means that their content is not, if it is all compliant from one end to the other, normally you wouldn't find their content in it. But the real problem is if you are not referenced in those foundational models, you're lost. So how do you, and that's what we're saying, how do you find techno-legal solutions where you can give structured, specific data that you control into the models, that you want the models to be able to correctly reference you, and not only what third parties are saying about you? And from then you can put into place structured licensing deals that are machine readable licenses, and where you can control how your data is being ingested into these huge machines.
Thank you so much. I think I learned a truckload of things, and I even loved the bonus about China, because I'm very fond of Chinese culture, and I always love having people giving me insights about how the system works. Thank you so much for everything, and as usual, I like to leave the last word to our guest. So, any last thing to add?
Well, we went through so many things, and we went through ourselves at breakneck speed, because pleased with our auditors, that they understand that I'm not giving a an in-depth IP point of view. So I have tried to sort of skim through things. Yes, I had a few points I wanted to speak about. I think we did a lot of them. Yes, I wanted to go through this one. It's something that it's important for me. When we look at songs, we look at music, when we look at a poem, fictional point of a fiction that's been written, we say, so this is an author's work and it's protected material. Clear for everybody. When that material is ingested into an LLM model, statistically, it's a data point. It's just data. And our understanding of data is non-proprietary. Do you see that we are structurally incoherent in those things? And I think that we have to, I'm worried, Gauthier, that some of these structural inconsistencies that we've had also with regard to data will not come back as a sort of Achilles tendon, a sort of weakness that we will have somewhere in those things. Because you see, we have to align the data aspect with the copyright aspect. And only if we align both of them correctly can we then find a way to bring in authors and recognize their work and give them fair compensation. So I think that we have some structural incoherencies and inconsistencies that we have to be very careful of going forward between data and copyright. They're totally different, okay? And we have to find some sort of alignment on that. The last thing was maybe the last, yeah. The last thing I would say maybe was about the control gap. I have written about that in the past, which is that it's an illusion to think that we are going to control the AI models. We've seen it over the last 2 to 3 years since chat came out in November 2022. We're only now starting to understand that black box. And a lot of that has emerged through the workings, the lawsuits, the licensing, etc., and we're coming to understand certain things. So we're not going to be able to control this thing as we think we can through regulation, as we said. So there's a huge control gap, and we need to address that control gap through techno-legal solutions. I come back to that one more time. And this is not tech lawyers. I read a wonderful contribution, which was very true, that right now in litigation, we don't have lawyers that are sufficiently tech that can explain to judges exactly in a very simple way all these huge technical realities. It's true that we need tech lawyers in a very let's say short-term period or middle-term period. But we need much more than that. We need, just like what we did in the Web3, which is very pluridisciplinary approaches in which you don't say code is law and you don't say law is the answer and a new regulation, but you really work towards something where lawyers speak to tech enthusiasts and coders, and we all try and speak a similar language to get to an understanding where we can address these issues, which are huge issues, IP and AI.
Thank you so much, Casey. As I said, I learned very much,
Oh, thank
everyone.
you so much.
This was Casey Jolie. Look her up on LinkedIn. She does many, many, many things. And this was Mutual Knowledge. Stay tuned for more episodes. Like, share, subscribe, yada, yada. Thank you so much, Casey. And maybe see you during a future episode. I don't know.
Sure,
Cheers.
sure. Thank you very much, Gautier, for having me on this issue of AI and IP. It's a huge issue. I hope I brought a little bit of insight, but it's so huge and there's so many things we can do. I would happily come back and speak again about it.
Thank you so much.